The South Carolina Eviction Notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery, and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in South Carolina. Non-payment notice. The South Carolina laws set a 5-day grace period for tenants failing to pay rent due. If they fail to pay rent within this period, a 5-day notice to pay or quit should be sent by the landlord. Non-compliance notice. If the tenant violates other terms of the lease, a 14-day notice to remedy the violation or quit should be given to them. It includes violations such as damaging the rental property, breaching no pet policy, health or safety violations. If the tenant was involved in illegal activity, the landlord is not obliged to send any notices to them before terminating the contract. What if the tenant fails to comply? If the tenant fails to comply with the rules of lease, the landlord might apply for a rule to show cause in the appropriate South Carolina court. The filing fee will depend on the county. For example, in Charleston County, the filing fee is $40. Then, the tenant should get the summons and the rule to show cause prior to the hearing by a person over 18 who does not take part in the hearing. They should respond to the summons within 10 days after receiving them if they want to contest the eviction. In some counties in the state of South Carolina, the tenant has to request a hearing in order to contest the landlord's actions. The tenant's failure to contest the eviction might result in a judgment in favor of the landlord by default. If the landlord wins the case, a writ of ejectment will be issued within 5 days of the judgment. The document will give the tenant 24 hours after it is delivered in person or posted on the rental unit before they will be forcibly removed from the occupied premises.